Good evening. I'm Ryan Sharp with the Utility and Transportation Contractors Association of New Jersey, or UTCA. For those of you who don't know, we represent and support anyone who works in or around the infrastructure construction industry. So thank you everyone who joined us, and welcome to our webinar on legal guidance for DBE contractors. This is one of a series of events that we are hosting to further discussion this issue and to assist DBE contractors. We hope you get some valuable information from the seminar, and we also hope that you will consider a membership in the UTCA, which we believe provides a lot of value. So thank you to our panelists. And with that, I would turn things over to our moderator, John Case, who is a former Chief of Staff of the New Jersey Department of Transportation and the current Vice President at Hawk Strategies. John?
Ryan, thank you very much, and thank you to UTCA for hosting this event. Before I start, I'd just like to point out that the information provided in this webinar is intended for general information purposes only and should not be construed as legal advice. And participation in this event does not establish an attorney-client relationship between the attendees and the presenters or organizers. That being said, thank you everyone so much for taking some time to join our webinar today and have our discussion. If you have any questions at all, please feel free to put them in the chat and we will review them and ask our panelists. Joining us today, we have Shawn Farrell and George Pallas from Cohen Seglias. We have Tobia Lovelace from Tobia Lovelace. We're going to give the attorneys a couple minutes to just talk about themselves and their firms a little bit, and we'll start with OT.
All right, thank you, John. So as he said, my name is O.T. Lovelace, and I'm a Jersey kid who went to school down at Morehouse College, came back up for NYU, and since then I started off practicing law in New York City at a big firm, and now me and my partner Ron Tobia have our own practice called Tobia Lovelace, where we kind of focus in labor and employment issues. A lot of our clients are just like you in the construction industry, putting down pavement on the roads across New Jersey and New York, putting up bridges, painting bridges. And, we also give counsel to various union funds around New York and New Jersey as well. I deal with a lot of cases with the Office of Federal Contract Compliance. I know how those issues go, and I know how to deal with those issues. I also work in a lot of cases with the Department of Transportation, in particular, the Civil Rights Department, where I deal with subcontractors and prime contractors who may have had, their contracts, big public works contracts bounced for various technicalities, something we'll get into today. My firm's had a lot of success over the past year winning those type of cases with the Department of Transportation. And we also do a lot of work throughout New Jersey dealing with, contractor issues, whether it's big or small, labor disputes, big or small. And we're very attuned with the different issues all DBE contractors are dealing with here in New Jersey, New York. Thank you, John.
Thanks so much, OT. John, George, I don't know who wants to kick it off first, but
I guess I'll kick it off. It's nice to be here, and I want to thank the UTCA for inviting George and I to participate in this seminar with OT. We appreciate the opportunity. We are a law firm that specializes in construction law, from bidding issues to contracting issues to disputes to resolutions, change orders, the whole 9 yards. And we really do appreciate the opportunity to come here and kind of educate people on construction law. It's a very heavily regulated industry. We're going to get into some of those regulations here today. And we look for opportunities to come out and talk to people. We have offices in 8 different states with over 90 attorneys specializing in construction law to help with those issues. And anytime we can support an organization like the UTCA to do that, we're happy to do. So, George, I don't know if you have anything to add.
No, I don't, Shawn. That was wonderful, and I think you accurately reflect the culture of our firm and our involvement in the industry, and certainly in the state of New York and New Jersey, especially. And I appreciate your comments, and we thank the UTCA for inviting us to participate. We're looking forward to getting into it today.
all right, great. Well, with everyone, thank you for telling us a little bit about yourself and your firms. One thing I think that comes up all the time in DBE issues is the commercially useful function requirements. And guys, what do you think are some of the key responsibilities involved in satisfying the profit that's referred to in the industry, and how do you navigate them effectively?
All right, I guess I can start off here. Thank you, John. Just to throw out the kind of definition that you'll find, a commercially useful function, it means that the contractor should be performing a distinct element of the contract scope of work, including supplying goods and services. You should perform, manage, and supervise the work that's being done. And also, you should be performing work that's normal for your firm firm and your business. So one thing we run into and issues we run into is the Department of Transportation or whoever might be evaluating the contract will look at the DBE contractor to see if that particular contractor performs the task that's been assigned to them on a regular basis. They want to know that you're actually a specialist, that you actually are qualified to do the work being performed. Not that maybe someone just hired you one off and you've never, for example, you've never put up a telephone pole or you've never put pipe in the ground. They want to know that you're capable, your firm is capable of putting pipe in the ground, putting up that telephone pole, painting that bridge. They want to know that it's something that you do on a regular basis, something you're comfortable with, and that you'll actually be the one doing it. If it's trucking, they want to know that you're the ones that their company actually owns the trucks, and it'll be your drivers driving the trucks, not just that you lease the trucks from the prime contractor. That's important. It comes up. Do you own the trucks? Do you drive the trucks? Can you actually do the work? And also, something you should remember is when they do quiz you on this, or they do test you on this, or whether or not your company, your DBE firm is capable of doing a commercially useful task. For people they talk to, whoever the president is of your company should be qualified to talk with experience and knowledge of that industry, that business. If you're being brought in as a trucker, whoever's being put forward to the DOL, the Department of Transportation, or New Jersey Turnpike, they should be ready to talk as if they've done this dozens of times. They should have done this dozens of times. So it's just something to keep in mind. Make sure that you're doing the task and that you have the equipment to do the task.
Yeah, I think that's a fantastic explanation of what a cup is and what you should do. I'd add to that to say, listen, there's a lot of times that, you get small contractors that are coming out and starting up a business. They might have some family experience with, fathers or mothers in the industry, and that's fine. And you can do that, but you still have to be the person. I think OT raises a big issue. If you're the one who's going out there and you're doing the work, you have to be the person who's actually making the decisions. And it's important to document, right? We want to document that in our shareholder agreements, buy-sell agreements, in meeting minutes of the company, when you're meeting with the board, or you're meeting internally. And when you have smaller companies, it's certainly harder to do because it just might be you and a secretary at times and seem like that. But you've really got to keep those emails and keep that chain of custody in case it ever does get questioned, that you'll know that you have the evidence to support that you're the one really making the decision and you're really 51% of it. For these DBE, MWBE programs, obviously the disadvantaged entity has to be in 51% of control of the company and making business decisions on a daily basis. And it's important to keep that kind of documentation going because there is, unfortunately, liability that lies on the outside of that. You could be disqualified from being a DBE contractor. There are penalties and there are fines and there's even imprisonment if you're potentially doing it in an illegal fashion. So you want to do that and make sure that you can demonstrate to others that you are the one in charge making the decisions.
If I can tag on to what Shawn said, years ago, those of us that have been around for as many decades as we've been around, back in the day, the cuff requirement was loosely followed. And you saw a lot of examples of DBEs being used as brokers on deals. That history, that process has now concluded. That's no longer going to pass muster. And the governmental agencies, DOTs especially, and any other state agency is going to look very closely at the cuff requirements. And, OT and Shawn are exactly right. You have to, in order to satisfy the cuff requirements, you have to actually be the party who's performing, managing, and supervising the work that you're performing. And what the DOT, they issue guidance on this regard. And there are 5 distinct factors that they're going to look at to test whether you meet the cuff requirements of a contract. They're going to look at your management, workforce, equipment, materials, and performance. And when you look at management, they want to know that you are personally, your superintendent is managing your work. That's important to do that. So if your superintendent is on the site, but really is just there as an observer, and the supervision is being done by the prime contractor, that'd be a strike against your satisfying the cuff requirements. Same thing with respect to the workforce. They want you to perform at least 30% of the work with your own forces. So they look at the value of your contract and they're going to be looking at, are you performing 30% of the labor to get that work done? If you don't do that, that's going to be a strike against you satisfying the cuff. You may not have to own your own equipment, but you can have to lease it. But you have to lease it using arm's length transaction, commercial terms. And if you can lease it with an operator, that's okay. That's normal in the industry. That's not a problem. Or you can operate the equipment yourself. But as Shawn said, you need to have the documentation to back up what that is. But you're the one who are required to procure the equipment necessary for you to perform that work. Same thing with the materials. You need to negotiate the material purchases, that they have to be delivered. The invoice has to be in your name and not in the name of the prime contractor. And finally, the performance, which is what Shawn and OT were referring to. You actually have to perform that work. And if you fail to do that, and you then are deemed as just a broker or a pass-through, then Shawn is 100% correct. The prime will not get credit for the DBE participation, and there could be criminal or risk of debarment from the DBE and the prime. So the cuff is a major issue right now, and the public and the governmental jurisdictions are extremely focused on it.
Yeah, just to piggyback on that, I definitely agree with both these gentlemen that paperwork is so important. I mean, you got a panel of lawyers, and one thing you can stress more than anything is that it's not just about what you do, but can you prove it? If you're challenged, can you prove it? So I completely agree with them that you got to be able to prove it with paperwork, that you own the equipment, or that you've leased the equipment through an arm's length transaction, that you're doing the work. Paperwork matters.
Yeah. Let me add, I see this a lot with family-run businesses that break off and the son or the daughter want to do their own thing. And there's nothing wrong with that. To be honest with you. And as heavily regulated as construction is, there's really no regulations coming out from the federal standards and the DOTs on how much influence a family member can have, right? So you mentioned, both you and George mentioned that you can take equipment or rent equipment. Often you're going to take that from your parent, right? If you're the child who's starting their own company, there's nothing wrong with that. The regulations say they can have that. Now, how much influence? And you have to be paid, the fair market rate for what that equipment is, or what rental charge would be. So you got to make sure you're doing that. Now, does that mean that you owe the fee for that immediately, like you were renting it from a normal distributor? No, but you do have to square it up on an annual or quarterly basis, and you have to have the accounting documentation. Speaking of documentation, that's what got me thinking about it. You better have the backup that you're really paying that money back to the parent company, literally meaning parent familial company, so that it's a fair market transaction. And those things are important because you've got to keep training people to know about that, and also your employees when you're in a business where you might have influence from a family member. Again, it's okay to have them on your boards. It's okay to ask for their opinion, but you got to make sure that everybody that you're working with within your own company knows the buck stops with you, that you're ultimately making the decision, and you should have those in your agreement, your shareholder agreements, your bylaws, and in your board meeting minutes.
So true. When it comes to things about influence, I know I've been in arbitrations where we've been the actual workers will be brought in to testify. And that'll be one of the questions. Yeah. Who is the owner? Who is in charge here? And they should point to that DBE owner. They should point to you so that you're the owner, not your dad or your mom or anyone else in the family. Right. The workers themselves should recognize you as being the owner of the company or the manager of the company.
Shawn, the documentation that you referenced, and just so that our listeners can appreciate that, we're talking about subcontract agreements. We're talking about leases, equipment for who owns the equipment, bills of lading. You need certified payrolls, copies of canceled checks, delivery tickets of material. It's all of those documentation in the ordinary course of business that you need to maintain in order to establish that you are in control and are managing the 5 distinct issues that I raised. When we talk about Shawn's talking about leasing or buying equipment from family members, that's not a problem. And often, many times, the DBE will rely on the prime contractor's trucks to assist them in lease from them. And what they do, many times you have those magnetic placards that you'll stick on the side of the truck, thinking that you're doing yourself a favor of putting your name on the side of the truck. That's a tell to the governmental agency that there's a problem. The placard is the problem. And that's how minute in the grains of sand that the governmental agencies are looking. So make sure you have your paperwork in place. And if you do that and you follow everything that we're saying here at this webinar, you're going to have no problem establishing the cut requirement.
Yeah, I think we could talk about this issue all day, but another fundamental area of documentation is who's on the banking document, who gets to write checks, right? So you should make sure, and sometimes with family members, you always have the issue, well, it was always me, until I wanted to take a vacation. And then I wanted to make sure the employees got paid, so I put my father or my mother on it, and then they started writing checks. Please, you want to have compliance and documentation, and you want to make sure you're doing it right. It's not that you can't go away for a little while and get it done with a third party, but change it back. Keep the documentation straight. Keep your banking records straight. Seek training from legal or compliance advice from people on how you're doing it and how you're setting it up, and when you can go back to, a more routine basis of where you're the only one on the banking documents. That's I think government agencies always follow the money, and they're looking at who has the ability to take money in and take money out of companies.
No, thank you guys very much. That was all extremely helpful information. One thing I think we've been seeing more often, and it's kind of a newer thing, is that you have non-DBE and DBE firms forming joint ventures to go after certain projects or things together. And I'm assuming that there's a lot of regulations and guidelines that contractors have to meet these standards. I know that you can form a JV between a DBE and a non-DBE, but can you guys talk a little bit about any regulations or rules that are required in order to do that?
Yeah, I think the primary thing that jumps to my mind first off is you can have a joint venture. You got to make sure the joint venture agreement, again, is clearly written as to who has control. Again, if you're going to take credit for the DBE program, the minority or the distressed business has to be 51% control. So it's not like the joint venture can say, I'm in control of this. And there are all kinds of unique ways to try to get around that. Don't do them. They track them down. I had one issue I was involved with where the JV rented back lease space to the DBE, but the lease had to be paid first, and the rent was exorbitant. So what they were doing is they were sucking out the profit from the job to the lease agreement. So while the DBE that had 51% control was ostensibly in control, really the money's flowing through, right? So there's all kinds of creative ways to do it. First and foremost, it's got to be a clear agreement, the JV agreement. You definitely have to seek legal advice on that joint venture agreement, but keep it 51% control. If you can't get into an agreement or a deal where you're okay with your partner having 51% control in the daily ins and outs of the business, it's not a good fit for you. If you can, then it could be a good fit. It could fit the project model very well.
John, let me jump on that, what Shawn just said. Yes, the advent of the joint venture with a DBE is very common. It's very common. And Shawn's right, you need a joint venture agreement that clearly lays out the obligations of each party. The reason why people create these joint ventures is that because they have the DBE who's at 51% and they have the non-DBE at 49%, and they create a separate entity under the joint venture agreement, a separate company, either an LLC or a corporation. And then they want to qualify the joint venture as a DBE so that the joint venture, they can take on much larger work for a larger project and take on much work. The problem is a lot of the DBEs don't have the financial strength or resources to do that. And so the tendency is, and the risk is that in the joint venture, while the DBE has 51%, you have the governmental agency will look closely at the joint venture agreement and any other documentation to suggest whether anyone else has control over that joint venture. And the tendency and the reality is the non-DBE contractor is going to try to influence control because they're taking on much larger work. So Shawn's 100% correct. You have to make sure you have legal counsel look at the joint venture agreement. Typically what happens is there's a management committee under the joint venture agreement in which the DBEs is a participant, so is the non-DBEs are participants in the management committee. It also dictates who controls the money, who controls the bonding, and who's on the hook for the personal guarantees on the bonding. Many times joint venture agreements will have a provision that says that the JVs that's created, which is the DBE now, has the right to subcontract all or part of the work to the individual joint venture partners. And that methodology of trying to get the work managed is another angle that the governmental agency is going to look at to see whether this is just a ruse. So you just have to be mindful because the joint venture, while it's a great process and it's very common, it's very common, it is fraught with risk that needs to be analyzed through counsel before you enter it.
I think one other issue we're seeing now with joint ventures is starting to pop up is, whether or not those joint ventures will need to get a separate public work certification. There's been talk about that. That's an issue on the horizon for people. So it's something to just keep, your eye on moving forward, that, it's a possibility that New Jersey will start cracking down on more of these joint ventures, whether or not that joint venture has actually obtained a public works certification to work on these public jobs. So just keep that in mind moving forward.
One thing that we've already talked a lot about here, and it's talked about a lot in the DBE world, is paper. And and essentially, the accuracy and compliance of bid packets and your documents that you put in there. Understanding these DBEs are a lot of smaller companies who they're out in the field working all day and then they're coming home and doing this paperwork. Are there any tips or tricks or any guidance you guys have for firms to just kind of get those get their paperwork as locked in as they can?
Well, we're in a lot of complaints from the DBE world that it's just too much paperwork, too many forms to fill out, especially our truckers. They've got to fill out form upon form. Sometimes there's only a few days to get all that paperwork in. And one of the reasons that we have DBEs is that they are disadvantaged. So they don't have the back office staff. They don't have the manpower to handle all this paperwork. One thing that we do recommend to people is that, to the extent possible, you try to set aside at least one person in your office that can manage these documents, because it's critical that all the documents get filled out perfectly the first time, because you don't get a second time to submit them. When you're filling out your 266s or your 273s for truckers, it would be the 274s, make sure that you're taking your time with those documents, that you're listing everything you need to list on those documents, that you're putting all your NACES codes on there properly. You have to really take your time when you're checking every checkbox. We're seeing forms being submitted that aren't signed, that perhaps are missing a checkbox here or there. You really have to take time to look at that. And we understand that it's time crunch. Someone gets awarded a job on Thursday, the paperwork's going to be due Monday, Tuesday. I mean, in these type of quick turnarounds, there's not much that you can do besides having someone who you're going to dedicate to that task. It's worth it, because if you do have that missing checkbox, if you do have that missing signature, what could have been a $4 million project or a $300,000 project, depending on your type of business, will be lost. So it's critical that you try to put some resources to the side for that task.
And just kind of,
Let's add to that at all, except maybe practically some advice might be to, in that regular training of having that one individual, maybe have a fallback person that's with them if you can, so that you both are there, two eyes on it. And then if one person's out or something, the other person who's, in the office can keep that paperwork going. So, but I thought that was, well said.
just as an adjunct, if I can, before we jump on to the next topic, many times what happens, you'll have a non-DBE prime contractor who has a favorite DBE who they like to utilize on their work, right? And they may even set that person up as a DBE and then start feeding that work to the DBE and assist them with their paperwork, assist them with and their insurance issues, and provide assistance. And there's nothing wrong with the concept that's there between the mentor protege program, especially in the federal arena. And there's nothing wrong with that. But the problem with it is the DBE gets soft. And there is something that's in the rules called the affiliation rules under the DBE regulations, which means that the DBE is deriving more than 70% of its revenue from one prime contractor over a 3-year period. Then there's an identity of interest, and the DBE then runs the risk of being considered an affiliate of the prime contractor, and therefore losing its DBE status. Now, with that said, that's a little problematic, right? So you want to get the work, you want to get trained, and as OT says, you don't have that back office resource. There's nothing wrong with contracting with the prime contractor to provide contract administrative services, provided it's done at arm's length. That means there's a contract to provide services. You're paying the fair value to provide bookkeeping, help you with your insurance, helping with the certified payroll. And if you're paying for that service, there's nothing wrong with doing that. But you have to, it goes back to the paperwork and trying to get support for that back office. That's another way to do that. There's nothing wrong with doing it that way.
And to add on to that, one thing I am seeing with the paperwork is sometimes kind of that relationship you were just talking about was you have a DBE will have a standard ongoing relationship with a prime. And some of the documents for that DBE just might be on file with the prime. Some of the trucking cards, some of the, various verifications and, DBE certifications that the DBE might have just might be on file with the prime. One thing you should do is make sure that paperwork is up to date. Is it expired? When was the last time you checked it? Are those registration cards up to date? Does it say the right year on it? And does it have all the up-to-date information about your trucks and everything else that might be involved? You know, that's what we're seeing too, is getting soft and being lazy. You know, you have to make sure that if you're going to put it on file with your prime, that you're checking and you're updating your paperwork so that when they do submit it, it doesn't get bounced for being incorrect or being expired.
I would just add to that, dovetailing to what you both said, be careful, DBEs, in just working with one general. Even in the short term, it's a slippery slope to circumstantial evidence looking like you're not actually doing the work, you're not even filling out the forms, you're having somebody else do it for you, and you only submit a bid to one contractor, that guy who's filling out the forms for you. The more that you're supporting the project in general and giving bid numbers to more than one contractor who needs to fulfill those obligations, the better off for you. I'd much rather see you contact and learn from a DBE liaison officer, you know, within the DOT, how you properly fill out those forms and compliance issues, and do it yourself. That's the safest way for me.
And just throw something else in there, because we're talking about, you know, tricks to maybe get your paperwork in order. You know, one thing that you can keep in mind is that a lot of this paperwork, it's going to be repetitive, you know, and if sometimes as DBEs, sometimes you'll be more of a prime on the job. You have maybe some people below you. Make sure that you're documenting your efforts to bring on other people on your project. So good faith efforts, that's something that's talked about a lot in this industry. Make sure that you're documenting your efforts. If you're a prime and you're still a DB, but you're a prime in that situation, make sure that you still have that paperwork to show that you reached out to other minority businesses to bring them on in the project to the extent necessary to get that job that you're working on. Make sure you have emails prepared. You can prepare some letters, emails in advance that can be sent out the second you know that you're getting on that job. Now, you have to follow up and you have to get this ready, but these are some forms that you can kind of have already ready to go, reaching out to certain entities that you know you're going to have to reach out to in a short time frame. So, you know, legal help, legal counsel, people like that can help you get those forms ready, but it's something that you can have ready to go so that you're not behind the ball when you get that job call.
And regular training. If you miss the mark on a project and forget to fill something out, let's train our staff to catch it the next time and be better the next time.
Okay, great. You know, so one thing, you know, as you know, DBEs kind of grow, and you know, sometimes they need new capital. You know, they'll seek investors, or you know, to sell a portion of the DBE off. What safeguards should companies implement to maintain majority ownership and prevent the sale of portions of their DBE that, you know, could put their licenses at risk?
Well, again, on buy-sell agreements, you have to make sure that you're not selling more than 51% of at the end, right? I see it more in a succession of business, right? So when people are coming up in the ranks and you're getting older and you're saying, well, okay, now I'm going to retire, but you know, we've made a business off of being a DBE or MWBE. How do you pass successively to the next generation down? And you've got to realize, if your business model is dependent upon those contracts where you're satisfying that someone in the lower ranks who's rising up satisfies that requirement and gets the proper training to actually run the business, right? I mean, I'll take an example, especially if you're in a licensed trade, if you're a plumber or electrician or something like that, you better make sure that someone behind you for succession planning is coming up and is going to go and get licensed and have a license so that they can take over 51% of the ownership of that company. And then you've also got to look at, okay, well, if this person is going to be 51% ownership for us to maintain our DBE status, what's that mean for others, and how are they going to contribute and stay, and how do you maintain that force? Which is outside the ambit of this seminar, but that's a succession plan you really should have in place.
Yeah, that's interesting. I kind of ran into something like that with some of my clients. And it came in the form of somebody was the 51% owner, but then the rest of the shares actually he was split amongst other siblings. And then when the father or the mother died, their estate documents changed the ownership of the company to the extent that one minority person was no longer the majority owner of the company. So I think when you have, close-knit families, own businesses that have, documents in the estate planning that might influence the ownership of the company, you should be aware of that moving forward too, how those, RATs and whatever type of formal documents they have, estate planning documents, how those been executed. Because sometimes there's a time delay in those documents. Right. They self-execute after 3 or 4 years. Make sure you're aware of that. Will your company's ownership actually change as a result of maybe somebody passing away? You're not even maybe thinking about at this moment.
Right. There's a whole level of complexity when you start bringing in estate planning into it. Also, if you're, a rising star in the company and you think you're going to take over and you're part of the family that's going to inherit a lot of money, you might be tapped out from the net wealth issues and how that estate is being transferred to you in the wills. You might, financially exceed the program. So there's a lot of things, a lot of complexity there.
John,
But those are the issues that you should be thinking about along those lines.
John, you mentioned in your question that there are some DBEs are approached to sell parts of their business, and what are the things that they need to be worried about. There's no prohibition in a DBE selling a portion of their business to a non-DBE company or individual, right? There's nothing wrong with that. There's no prohibition against doing that. And as Shawn indicated, the DBE still needs to maintain the 51%. But what happens in that arrangement is many times the DBE is looking for resources, and you'll have a non-DBE entity perhaps buying up a minority interest in the company. Then you fall into the trap of trying to provide too much assistance, too much oversight, and that's a slippery slope that Shawn was referring to, because you can't sell 49% of your company and then move your offices into the non-DBE's primary office, and you're down the hallway. That would suggest that you're losing autonomy. You can't have all the work being managed or as employees switching back and forth, or because you get it considered to be assumed within that. And DBEs, if you are going to sell any portion of your business out, there is a notification requirement. There's a change in ownership notification requirement under the Unified Certification Program that you have to notify the agencies within 30 days of that change, and you need to do that. And there's nothing wrong with it. There's just a requirement that you do that. And so the DBE who wants to sell part of their business, they do so because they want resources so they can get more work, right? They're trying to get more work. But there's also a gross receipts requirement that if the gross receipts of the firms of the DBE over the past 3 years is in excess of 27 million, 26 and change, you're no longer DBE. So it gets you up to a certain level, which is good, but you have to be mindful of that. You need to be mindful of the personal net worth requirement, which I think is at 1.32 million now. And then I worry about the affiliation rules, that if you have a non-DBE part as a shareholder in your company, then now all of a sudden you're getting, the DBE now is getting all of the work from the prime. You become an affiliate, and that can jeopardize your DBE status as well. So none of this is illegal, none of this is wrong, and there's good business reasons for doing it. It just has to be done properly with your eyes wide open and your ears cleaned out, so you're listening and hearing and doing all the things that you need to do in order to maintain your DBE status.
Sure, great. Thank you. All right, we can talk a little bit about NAICS codes. And, what steps should businesses take to ensure compliance regarding their NAICS codes, knowing that there are variations in the revenue thresholds for them, and how important is it for businesses to accurately classify and report their activities under the NAICS codes?
This is fine. So, John, that's something we're seeing a lot right now. There's definitely been a crackdown. The Department of Transportation, particular Civil Rights Department, we're seeing a strict, focus on whether or not the DBE contractor has the proper NAICS code to do the work that's being performed. Now, one thing that we're recommending to all the contractors that we come in contact with, that we counsel, is that you check what you've actually been certified to do as a DBE contractor. It may be very nuanced. So you may be certified in landscaping, but you might not be certified to plant trees. Maybe just certified to plant grass and shrubs, but not trees. It's a nuanced thing, but it's something that they're looking for now. Did you get that extra qualification? So you need to go back to whoever certified you, whether it's Department of Transportation, or maybe it's New Jersey Transit, or some other agency, whatever agency it is that gave you that certification and gave you that code. Make sure that that code covers all the work that you actually perform and you know how to do. Don't limit yourself. That's the biggest thing. A lot of people say, oh, I can plant the tree. I've done it many times. But you didn't get that certification. You didn't make sure that it was on that piece of paper. You didn't have the paper trail to show that you're certified to do it. If you do bridge painting, make sure you have the code that says bridge painting. If you do heavy highway, it should be there that you do heavy highway. Make sure that's there. And be careful, though. There are times when you become too big for that particular code. We're seeing that come up now, too. They're cracking down on that as well. Is that DBE contractor too big to maintain that particular NAICS code? So those things you should be cognizant of. Are you certified in all the crafts that you actually can perform? Have you gone back to update that? And if you are getting too big because of your success, You know, are you careful that now, look, maybe you have to journey into other areas. You have to put yourself out there and hold yourself out to do bigger jobs, different jobs than you were doing in the past, because maybe you no longer qualify because of how much money your particular, firm is making. But the biggest thing we're seeing is a big crackdown on whether or not the NAICS code that you have actually says the task that you've been performing, that you're going to perform, down to the exact wording. Don't allow yourself to get bounced because you're missing, like I said, it says grass, but really, you need to build in a tree. Make sure you have all your codes up.
National company.
I'll only add to that to say, I've definitely seen what you were talking about with the revenue issue, where you outgrow the code itself. So I would say, when you're thinking about it, look at the thresholds of revenue and where your company is and where you really want to grow. To your example, if you're, a landscaper and you're growing grass or planting trees, well, if you really want to do 95% of your work planting trees, right, then understand what that revenue is. Be looking at it yearly so that you're compliant with the code and not taking on work that would put you in a violation of the code. And pick a code with the highest amount of revenue possible if that's your work and that's what you're going to do. So you don't have to change it. You can change it, but I think you'll agree with me, OT. It's a pain. They're very sticky and they don't want to change it after they've already accepted you under one code, especially when you're hitting that dollar threshold of revenue.
Just so everybody's aware, and I agree 100% with both Shawn and OT. I think you're 100% right. They're cracking it down. But if you speak to civil rights, there is not a uniform application of how these NAICS codes are being applied, because many of the DBEs are certainly qualified to do a lot more than they're doing. And when they started out, they maybe got one code or maybe two, but in reality, just based on their experience, they can do much more than that. They don't have that NAICS code. They've been doing that work, but they're not getting credit for it. But the guy down the hallway is getting credit for it when they don't have that code. It is a problem. Civil rights knows it. I've had at least 3 or 4 issues with civil rights representing clients on these type of issues. And they're trying to do the right thing, because you can point out, you all know, especially in public bidding, those who are getting credit for doing certain work that you can do and are in fact doing, but don't have that code. So to get the code changed and to get or an additional code, it's a process that takes time, and it's a frustrating process. But OT's 100% right. Review where your NAICS codes are. Look at the current listing of them. What other work you can do? Figure out whether you need to expand your capabilities or not, or limit them based on what Shawn was indicating. But it's about being on top of your codes, and so that you can maximize your potential business opportunities.
And we don't really see an end to this scrutiny kind of coming in the near future. I mean, we saw last year, the Supreme Court, took a big slap at affirmative action programs. We're dealing with, in particular, the colleges. And we're seeing now affirmative action programs, DBE programs across America tightening their belts. They realize that there are certain actors, certain people out there that don't want these programs to continue. So they all have to justify why they're here and that they're still effective and they're providing real service. And I think that that's what we're going to see with all these type of organizations that have affirmative rights, civil rights types of programs. They're going to have to justify the existence of their program, and that it's actually doing something meaningful to help this industry here in New Jersey. So they're going to continue to look at your codes and make sure that you've got the right code before they let you work on that job.
And regularly review the code and where you're at. I mean, for SBAs, for example, there's, thresholds of how many employees you can have, right? So manning up a job to be compliant with a general contractor's request for you to put more people on the job is one thing. But if you exceed the SBA requirements for a number of employees so that you're over that, you could, run into a situation where you're no longer qualified for the code that you're in. So to regularly review those records and know the decisions that you're making, you'll put yourself in the best way to stay compliant.
And would there be situations where you could, like graduate from one code to another kind of, with the dollar amounts? Does that come into play at all? Or?
Absolutely. I think
Yeah.
we're talking about that.
Yeah, yeah, exactly. So one code could say you can't have more than $1 million, right, in revenue. But another code of which you comply with, it's sort of an umbrella, landscaping being a perfect example where you have multiple tasks with under that bigger umbrella of landscaping. It's what codes or code you're taking. Some people just want to get in and get working. They'll get one code of what they were doing. Like OT suggested, you're just going to go for planting grass as opposed to planting trees, right? But if you're doing both and drawing revenue for both, you could outgrow the one code if you just pick planting trees that has a $50,000 threshold and grass is $1 million threshold. Well, go for the grass, get that code in as well, so that you have that, so you can stay compliant and keep bidding, even if you want to add on different codes at different times.
Okay, great. At this time, I'd like to ask if anyone has any final questions for the, that's participating, to put them in the chat. And I'd like to take a minute to thank the Regional Alliance for Small Contractors, NJDOT, and New Jersey Transit for sending this invite out to their list to help grow the event for this. We really count on you guys and appreciate your help in putting these events together. I'd be on the lookout for a couple more events. We're going to try to have one on access to capital and bonding, and something where we can talk about insurance for DBE firms. And really, at the end of the day, we're just trying to open up communication and help DBE firms get as much guidance and assistance as they can. So with that, not seeing any more questions. Dan, do we have any hand raised or anything?
Not seeing anyone.
All right. Well, Shawn, OT, George, thank you guys all so much for your time. I think this was a really good conversation, and I'm hoping everybody got a lot out of it.
Thank you.
Thank you very much.
Thank you very much.
Thanks for hosting, John. Thank you, everybody.
Lori just said thank you. Thank you, everyone.
Thank you.